Get down.
Welcome back to the North Carolina Real Estate Show. I'm your host, Tiffany Weber. I am an attorney at Thomas & Weber in Mooresville, North Carolina, and I'm joined today by another attorney at our office, Erin Weatherman.
Hello, everyone.
So assignment, that is when someone other than the party that was contracted with is going to perform under the contract. That could be buyer or seller, although it's much more common with the buyer. And a lot of times that's like, okay, say it's a buyer who identified, wholesalers do this a lot, a buyer who identified a property for a good price, but then they're going to turn around and sell it at a higher price to the end buyer. Well, they do that by assigning the contract to the new buyer. And the contract says that it cannot be assigned without the written consent of all the parties, except if there's a tax-deferred exchange. That's because an exchanger needs to be involved. We'll talk about that in a second. But in all other scenarios, written consent of the parties is required. Now, this is not assumed that the parties have to consent. There's no term in here saying, and that consent shall not be unreasonably withheld, conditioned, or delayed. Be unreasonable. I'm not suggesting. I don't want to rephrase that. Don't be unreasonable, but it's not in the contract that, you have. It's in your discretion.
Yeah.
You assign it or you don't. You consent or you don't.
Yeah.
And that is up to you as the party because you agreed to sell or buy with this specific party. And if a new party is coming in, it's up to you to decide, are you going to be doing business with that party?
Yeah.
You want to have dealings with them, yes or no?
So talking about assignments, I have seen on a number of contracts, buyer's name and or assigns. Mm-hmm. Okay, so if I put that on my standard offer to purchase, do I still have to get the consent of the sellers to assign the contract, even though my contract already says or assigns?
Well, that one's an interesting one because if we were to talk about the exact right way to do it, mm-hmm. This paragraph still says what it says. It may not be assigned. So and or assigns is not the assignment. Okay. It's the identifying that you may intend to assign. So it puts the other party on notice that you're intending to assign the contract, but it is not the assignment in and of itself. So under the express terms of the contract, it says this may not be assigned without written consent. So when it comes time to do the assigning, then you have to identify who the assignee is, and then everybody has to sign off. I have seen, though, where because of the and or assigns, the other party is just like, yeah, whatever. That doesn't mean it's the correct way to do it. So The absolute correct way to do it is you still need the assignment, you still need the consent. But it is good practice if you're planning on assigning. You can, say and or assigns, and I don't see any reason why you couldn't do an attorney-drafted addenda saying, altering this, saying that the contract's freely assignable without written consent of the buyer. Yeah. You can do that too. So tax-deferred exchange. In our closings, we have this thing called a settlement agreement and waiver. Basically, all the stuff that you don't want to have 30 pages of documents for, we put into one document. And one part of it refers to, hey, you didn't intend for this to be a tax-deferred exchange because we would need to know about it, right? Yeah. And people will say, well, what's that? I'm like, then you didn't intend to do it. Yep. If you don't know what it is, you didn't intend to do it. But it's a way to, say you're selling an investment property, you can have the exchanger or a qualified intermediary, they're called, take the funds. You never come into possession of the funds because that's when you get taxed. Mm-hmm. So the qualified intermediary takes possession of the funds and then uses those funds to buy you a new investment property within the prescribed time frame from the IRS. So right now it's, I believe, 45 days to identify, 180 days to close. If there is a tax-deferred exchange being involved, so say the seller intends to do tax-deferred exchange, sometimes called a 1031 exchange because that's the code that allows this, there's going to be another party involved, the intermediary. So the buyer in that case, the contract says that you agree to cooperate in effecting the exchange. You'll do essentially whatever is reasonably necessary to do that, but you won't incur any extra charges or liability for doing so. Yeah. Really, it doesn't affect you if the other party does a tax-deferred exchange. It's only a benefit to them tax-wise, and it's kind of like, hey, it doesn't hurt you at all to let them assign the contract to the qualified intermediary. It's not really changing the identity of the parties, and that's why you don't need the written consent to assign. Tell us about paragraph 17.
So the parties is all about this contract shall be binding upon those people that we put on page 1. So buyer and seller. And it's also going to be binding on their respective heirs. It's not a common occurrence, but it's not unheard of that somebody dies, a seller specifically.
Yeah.
We've talked about buyers can back out anytime. Sellers, it's not as easy as that. And so when a seller dies and they're in the process of selling their property, they are still in the process of selling their property.
Yep.
So just because they're dead doesn't mean, oh, well, I really wanted Grandpa's house. I'm sorry.
Yeah.
Grandpa was selling it.
Yep.
And so you now get
Yeah.
to sign with the rest of the heirs, or however the will states. This is me endorsing you getting a will.
Yes.
Call
Call Aaron at Thomas and Weber.
Yeah. And so, or however the will states. And so you are still under contract for that property, even if somebody passes away.
Yeah, that can get tricky because, as you said, the heirs may have some expectations of, I thought I was getting Grandpa's house. Well, if Grandpa had already signed the contract to sell it, you weren't getting it anyway. And the buyer can't be prejudiced by this. It's sad. We always feel very bad for the seller in this situation and their family or whoever their heirs are. It's not easy. It's not fun. But the buyer, they didn't do anything wrong. They shouldn't be prejudiced by this. So the agreement will be honored. Yeah, I think that's a really good, simple way to explain that.